Hello everyone, welcome to a little law lecture today. Thank you so much for joining me. We'll get started in the next couple of minutes. I'm just going to wait, it's 1 o'clock, people might be having lunch. So I'm just going to wait to see if we've got any late stragglers while I pull up the Slido. And Slido is going to be our way of communicating for this lecture. So obviously I can't go, okay, what are you thinking? I can't get your questions directly, so Slido is our way to communicate. So if you have any questions throughout this lecture, chuck that stream of consciousness thought down into the Slido and I'll be monitoring it throughout the lecture. They've been a little bit quiet for the rest of our uni lecture series, which is totally fine because you guys are not even week 1, potentially a lot of you, pre-week 1 uni. I was going to say, you guys are week 1, right? UNSW students will be week 1 at the moment if you attend UNSW. So if you are still getting ready for uni, you're getting set up and everything, don't stress. This will be just a nice intro lecture. It's really not about getting you all the detail. And the thing is that's actually a really good thing for law. So you'll see a Slido question popping up now, which says, what state are you tuning in from? And the reason why that's important for me to just get a sense of is that, law is very, very based on state. So I can talk generally about principles, but it's not necessarily going to be easy for me to give you all the information purely because I go to a Sydney school. I have learned Sydney law, and in some cases for things like case law extends. It's high court cases, so they extend throughout the whole federation. But sometimes specific statutes, like if I talk about something, the Civil Liabilities Act, you might be going, hang on, we don't have that here. I mean, everyone's got a Civil Liability Act, but that's not the point. So we're having a pretty solid split between the states, so that works out well for me. This lecture is very much generalized in the sense that it's all about the principles that uphold the first year of your law degree. And even beyond that, we're going to go into some stuff that's a little bit further beyond first year stuff. So you get a little bit of a taster of second year, third year ideas, depending on what order your uni does courses in. Because that's the other thing with law, we don't necessarily follow order. Most of you this term will be doing something like an introduction to law course and maybe torts or some other kind of foundational course. You might not be taking criminal law until year 3, or you might not be doing admin law till year 4 or something like that. And that's totally fine. So if you see something in this lecture today and then get to the end of your first year of law and go, hang on, that chick from Uni Notes brought up something and I haven't used it once. What the hell? Don't stress it at all. That may be because simply you just haven't covered it yet, and that's totally fine. So this is giving you that context to succeed and also to get your brain thinking about some big ideas, because law is very much a thinking subject, as annoying as that can be sometimes. It's all about, we have ideas and we're applying those ideas to something else, basically. So we might get started now. If you see me looking over to this side, I don't think you can see my laptop screen. That's where I'm just going to have the Slido up and running instead of on my phone, just because it's a bit annoying to keep opening my phone. And other than that, we can get started. So my name's Bella. I'm currently attending UNSW, as I kind of said. I am not just studying a law degree, so a lot of you are probably studying a double degree. Some of you may not be, which is also very sick. But I'm studying a double degree with politics, philosophy, and economics, or PPE. I now just have to explain what that stands for because I say I'm studying a PPE degree, and everyone's like, studying masks and gloves? So it's politics, philosophy, and economics. It's a bit of a chaotic degree. So in total, it's 6 years of study, presuming I finish on time. And to be honest, I might not, because who cares, right? Which may seem a bit long, but after 2 and a bit years of COVID disruptions, it's not too bad. I kind of only feel like a second year this year. It's weird to think that I'm in my 4th year. Some fun facts about me is that I got really into plants over lockdown, which is now causing an immense stress on my mental health. I went to Europe over Christmas, which was super fun. Well, not over Christmas, over December, and got back in time for Christmas. I do a heap of ocean swimming, which is fab. I love it. I only really thought about doing law in about June, July of my HSC year, so my year 12 year. It wasn't just a thought. For a hot while, I was like, yeah, I'm going to do medicine. Then I was like, yeah, I'll do journalism. And then it was a bit like, I don't know what I'm doing. Maybe I'll do law and figure it out. I did not study legal studies as a result, that means, right? So if any of you are sitting here going, I didn't study anything to do with law in high school, that's totally okay. It really does not put you at a disadvantage whatsoever. It might feel a bit intense the first couple of weeks. You might have all these people in your class that are like really good and know what they're doing and all this, and you're like, I've never heard of these things before. Why do you know what's going on? But after kind of the first couple of weeks, that you're all on the same playing field. UNSW is obviously known for being a bit controversial with trimesters. I actually kind of like trimesters, I'm not gonna lie, and most importantly, I really love the degree I'm studying, which is fantastic because it makes it a lot easier to do. So thank you to those who've responded to the poll about what state you're from. It's a pretty even mix, which is fine. That doesn't really inform my lecture too much, but it's just good to get a sense of what's going on. Now, so I mean, even though I'm wearing a blue shirt that says the wrong name at the moment, but I am today representing uni notes. So a lot of you guys were probably familiar-ish with ATAR notes in high school, and that's probably, hopefully, why you've come online today. Let me just have a look at something. Okay, some of you are a bit quiet, but that's okay. And that's probably why you've come online today. You kind of had a familiarity, you might have gotten some help or felt helped throughout your HSC, and now you're like, oh, let's give it a shot. So Uni Notes is separate but connected from ATAR Notes, and it's effectively continuing to allow you guys to feel supported throughout your uni life. So at the moment, it's a nice, chill, like intro to these subjects, but we'll see how we go throughout the year. We might get a bit more into the nitty gritty about, intro to torts or something like that. But as a part of our offering, much like ATAR Notes, it's all free resources to help you guys succeed, created by uni students. So I'm studying law. Chloe, who did the biomedicine lecture on Monday, is studying biomedicine, all those types of things. We're not teaching it for funsies. We're actually being able to give you that kind of advice and guidance and also share our love of subject. So throughout through Uni Notes, we provide these types of resources. So we've got lectures, which you're watching right now, but we've also got some free study notes that especially will be launching over the next time. So in roughly about a week or two, maybe, there will be a bunch of free law notes that will go online that will break down heaps of content. So there'll be one on intro to law, one on tort, one on civil law, one on criminal law, one on admin law, all these types. Very short summaries, 2 pages, 3 pages, just to give you that intro for now. As we kind of expand, people will be able to submit their own study notes online that you can then use and download for free. There'll also be our discussion forums and communities so that you can ask questions, say, hey, I'm in 3rd year, I don't know what course I'm meant to be doing next, or hey, I'm kind of just a bit confused about the whole timetabling process, all these types of things. Because uni's pretty stressful. You kind of get thrown in the deep end and it's like, okay, I guess I'm doing this now. And it's a bit chaotic. I'm thinking about my first term, which was pre-COVID, which was fab. Well, the first 5 weeks were pre-COVID. And I think I was in at uni like 4 days a week because I was like, yeah, that makes sense. I'll go in for 2 hours, even though it takes me 2 hours on the train to get to uni. And then you just kind of get the hang out of trial and error and out of kind of learning from other people around you. But this allows you to kind of have that other level of support. And one of our most exciting things that we're starting and launching is our subject reviews. So what this will be is, especially for electives, so for a lot of law, you kind of just have to do what you have to do for probably about the first 3 years. And then once you get a little bit further in, you get to be able to pick electives. So subject reviews kind of steps in for the electives, especially to see if you want to weigh up, like, do I study this course? Do I study that course? There'll also be reviews for the core courses, like tort, like intro to criminal law, whatever. That basically, and you don't have a choice, you have to do them, but it still might say, hey, so it's marked not too harshly, your assignment is a research essay, this is what it is type thing, rather than just being like, go for it, have some fun. Each subject, because it'll be run by a different convener at uni, may not be all organized in the same way, and sometimes it's a bit hard to figure out like what's actually going on in this subject. before you start the subject. So that gives you that little bit of context. Might not be 100% accurate, you know, if you're looking to study a subject in 2024 and the reviews from 2022, things might have changed a bit, but it'll still give you that context. And as I mentioned, there are some free course notes coming soon. So if you go to uninotes.com, we'll be able to give you that kind of intro to some fundamental knowledge, fundamental foundations, sounds a bit silly, about the degree. So it'll be content summaries. So like, what's the principle of beyond reasonable doubt? What's sentencing principles? Those types of things. So basically a nice intro. It's not going to give you all the information you need because, as I said, like the cases may not be the same. So I'll chuck in some cases, some legislation, but if it's New South Wales based, like if it's an act from New South Wales, the sentencing guidelines, let's say, and you're in Queensland, in your essay, you're not going to cite a New South Wales law. You've got to then go and find what the relevant statute is for your state. So it's very much overview with some really interesting information, looking at those kind of key precedent cases. But it's meant to be that springboard is the correct word there, that you can kind of propel into and feel that kind of confidence already going into your subject. Okay, so yeah, as I said, sign up to uninotes.com and that will keep you updated on what's going on. The great thing about law is a lot of you may be doing a double degree, so you'll be able to actually get twice the benefit out of this. Because if you're doing a law psychology degree, you can use both of the guides. No politics guide yet, because that's a bit of a vibe one. So, we're either in week 1 or about to start law. Now, this is the classic. You're going to get asked it in your first lesson, so you better get prepared. Let's do a quick little tag yourself, law edition. Because you're going to get asked why you've studied law, and a bunch of you have probably got an answer loaded, and might be that when you were young, your mum always said you were really good at arguing and you should do law. It might be that, who was my third one? It might be that, you know, you really watched Love Suits and you kind of just love the vibe and you didn't know what degree you were going to do, so you thought may as well, you know, those types of things. It's a bit silly, but let's have a look. Let's tag ourselves as lawyers here. Now, if some of these people aren't familiar to you, that's it. You'll find out soon. I know I've picked 3 fictional characters and then, you know, arguably one of the most iconic justices in the world, but that's okay. We can do this. It's a bit silly. For those of you that are a bit on the nerdier side, which let's be real, is a lot of us here, we're studying law, it is totally okay to be going into this law degree kind of hoping that you want to change the world. I'm putting that out there because some of you might be thinking like, oh, I'm a bit earnest, and that's totally fine. You absolutely can be. My thing, people always ask me like, why did I pick law? And I always start with, well, it was a bit idealistic and I really wanted to make a difference. And now I've kind of figured out, yeah, you can actually do that. Which is pretty great. So just to get your brain ticking and to get you thinking about stuff as a bit of fun, because that's the other thing, law can be a rough subject. Not rough in the sense that it's unpleasant, but it's not easy because you're covering a lot of information and you're dealing with a lot of complex topics. But the important thing is you do still need to try your best to enjoy yourself, as trite as that may sound. That is how you're going to survive, is spending time with your friends and having a good time and watching cheesy American courtroom dramas and pointing out how silly it is and all those types of things is absolutely your goal here. And thank you to those 7 people that are consistently responding to my polls. I very much appreciate it. But yeah, that's just a silly thing. I started my HSC lectures with a tag yourself thing just to keep the vibe light. And I went, well, let's do it. So, as I kind of mentioned, if you have any questions at any point, please ask on the Slido, which should be just below your screen right now. Please feel free to ask really anything, within reason. It is monitored, so don't be silly, but they are completely anonymous, so you don't have to worry about asking a silly question. I'm not going to know who you are unless you rock up and find me at university. If it's content related, I might not be able to give you a 100% answer. I'm not an encyclopedia. But they can be about law in general. It can be about university life, which I'm happy to chat about. It can be about jobs and clerkships. It could be about exchange. I don't know a lot about it, but I can do my best. Or basically anything. I'm here for you guys to basically walk away from these 2 hours and go, okay, feel a little bit better about this whole university thing. So, our lecture is covering a lot. It's a thick boy today. I think. Yeah, I know. I wrote up this summary and then I kind of made the slides. I'm thinking, did I cover everything? I don't actually think I did, but that's okay. I'll talk about some of them off the cuff without some slides. I think I may have forgotten one, but that's all good. So we're covering 4 content blocks today. Normally, if you've attended an 8R notes lecture or even another uni notes lecture this season, it's generally 2 or 3 content blocks. I'm cramming some more in. So we're going to cover the first 2 content blocks, have a bit of a break, and then cover the last 2 content blocks. I have tried to delineate law into kind of 4 separate areas. The first being like general skills and vibes, second being private, third being public, and fourth being criminal. Law isn't necessarily that siloized, and quite frankly, some things of this, they will get mixed. Private law especially, I've kind of merged about 5 separate subjects into one banner. While they all technically come under private law, it's a little like torts is technically private civil law, but it's also kind of often just seen as its own thing because it's got a lot more history attached to it. But either way, we'll muddle our way through. So we're going to start with some legal skills, which will include a generic structure of the legal system. Basically, I'm not going to get into the nitty-gritty history. You guys will do that at uni. Don't give up on that. It might feel a bit boring as you're doing it because you'll go back to some old English history and all this kind of stuff. And if you're a bit disconnected from that, don't stress. Just power through. It will get significantly better. They just have to teach. Do they have to? They have to teach it to you. So you've just kind of got to push through that. I won't be going into that really nitty-gritty history because quite frankly, I've got 2.5 hours and I'm not spending my time on that, but I will go into a little bit about how Australia's legal system is structured. Then we'll go into a bit about statutory interpretation, which will be in any subject that involves statute versus case law you will use. And then we'll go into a little bit about research, writing, and analysing, how to structure a law response. Then we'll move into contact block 2, which, as I said, we've merged under the banner of private law. So that'll be contracts and trusts, torts, and alternative dispute resolution. And I've got a little bit of a brainstorm question here for ADR. So your job is to switch on just for a moment, just have a think. Content block 3 will then move into public law. We'll be looking a little bit more in detail about why the Australian legal system and political system is the way it is, and a little bit about how we can hold that system to account through Parliament and tribunals. And then in content block 4, we'll be looking at criminal law. So looking a bit about criminal responsibility, bail and sentencing, the purposes of criminal law. I did forget to make a slide on mens rea and actus reus, but I'm going to explain that just verbally. And I actually did decide to skip police powers in the end because I'd get too bogged down. I could talk about police powers and royal commissions and all that kind of stuff, but we will not cover that today. It will be covered in the notes going online, however, because that way I can bust out some more statistics. It's a little bit of a more intense topic, which is really also dependent on who taught it to you, and depending on what uni you go to, some will have a different lens of I guess the way it's taught, whether it's black letter law, more critical law, etc. So that will be covered on the notes, not in the lecture today. Okay, let's start on legal skills now. And as I've kind of foreshadowed here about talking about separation of powers, how we can hold it to account, looking at a bit of alternative dispute resolution, and as I said, looking at police powers, the one thing you'll notice already is law is a subject of critical thinking. To be a good law student, you want to be curious about the law, but you also want to be understanding how it can be improved, and why the law often doesn't work as well as it should be. So in at least one subject a year for me. One of my major essays, i.e. worth 40% of my grade, has been something along the lines of, does the system actually work? And why should it be changed? So you don't want to just go into a law degree being like, yep, I'm learning stuff, I put it out. And to be honest, you might end up doing that as a career, and that's totally fine. But you'll get more enjoyment out of your degree if you're able to think critically about what you're learning and whether things could be improved. And that especially is pertinent for criminal law, which we'll get to in a second, and I'll discuss that. You'll see a little change in the tone of my writing. I'll be like, oh, politics, stuff like that. So that is, again, also because of who taught. UNSW does 2 criminal law courses. The second one is more traditional, like, here is assault. It is a crime. You have to wanted to assault someone. You have to have harmed someone. But we also do a crime in the criminal process unit, which is more about why are things crimes? Why do things work the way they do? And that's second year if you're going to UNSW. But that made me very critical of things. So you will have, I think, a more enjoyable time in your law degree, and hopefully you'll all always have an enjoyable time, but you'll definitely have a more enjoyable time if you continue to think critically about what you're learning and think about why have certain laws been formed in the way they are. But I guess the thing is, sometimes the law is a bit uncomfortable, so make sure you enjoy that, I guess. So this section is, as I mentioned, less content-based and a bit more vibe-based. So this is going to give us a bit of an introduction for those of you that did legal studies. In terms of how parliaments work, what's the structure of our court system, etc., etc. By the end of this, roughly like 20-ish minutes, 30 minutes, you should be able to have a brief understanding of the makeup of the courts and the government, and hopefully be on the way to developing your critical reasoning skills. For those of you that did an equivalent to legal studies, I'm not sure what it's called in other states, legal studies is often about using cases as and studying law in a, this is the law, this is what it does type way. Law degrees kind of take that a bit of a step further. Instead of just taking the cases at face value and just using them as evidence, you will be more analysing. So you'll be given facts and then applying those cases you may have learned about in legal studies to those facts. Now, as I said, there is still that opportunity for being critical and for being calculative in terms of how you determine what cases to use, and also how you determine whether the cases should have been decided that way or whether the law is upholding its purpose, etc., etc. The majority of your final exams will involve some type of analytical side rather than research-based critical side, if that makes sense. Now, that will be different depending on the subject and stuff like that, but most of your final exams for these subjects will involve, here's a set of facts, here's the circumstances. Generally, it's very wild. Lots of stuff going wrong for these people. And then you have a question that's basically like, what charges will be laid? What are some defenses? And you have to go, okay, what are the issues I need to work out? What precedences do I use, etc., etc. The scenarios are all made up. They're a bit wacky and wild. And I imagine unis will start making them even wackier and wilder with even sillier names, because last year there was a bit of a scandal at Sydney Uni Law, which you guys can have a Google of if you wish. It was a bit chaotic. And it wasn't funny for the people involved, although it may have been used for other purposes, but it was very funny as a law student to be like, yeah, the scenarios are pretty wild. Okay, let's get into a bit of the nitty-gritty about how Australia's legal system works. Bear with me for a bit if this seems a bit boring. I promise it won't be for much longer. So, Australia is a common law system. What this means is that we use cases to guide judges. So judges rely on previous cases that can stretch back to the 1800s or even further, quite frankly. Some of the ones are like age old. In order to make a correct call. Now, common law has also been enshrined by statute, so a case goes up and then the government might write a law. That's the traditional law you're probably familiar with, acts, etc., etc. It's kind of a symbiotic system, right? Cases exist, statute solidifies them, cases will test statute, vice versa, basically. It's a bit of a cycle. But common law originated using common law is what it's called, using case law. Cases that are able to guide judges and compare. So precedents, basically. The majority of our legal history, as opposed to our political history, comes from the UK. In our public law section, we're going to talk a little bit about the nuances of that, because we do borrow a fair bit from America. But we are a Commonwealth common law system. So our firmest, for things like torts, trespass, etc., the cases you will use will generally be from like the Queen's Bench or the Privy Council, which are UK courts. Purely because like they've decided it, and when our court system was set up over here, they went, yeah, sure, we'll just take that. That's our law. The reason for this being that, and I'm not going to get too into the nitty-gritty of the history of Australia's colonisation, because you will learn about that in your first unit. But the short story is, British colonisers deemed Australia to be terra nullius, i.e. land belonging to no one, because they didn't see evidence of a cohesive society. Now this was absolutely mistaken belief, obviously, and 200 years later, it will be determined to be legal fiction, directly determined to be completely false in the Mabo No. 2 case. And this is also why we see a completely different relationship between colonisers and the Maori people in New Zealand versus in Australia. It's about how our First Nation society functioned in terms of not quite being hunter-gatherers. They did have farming societies, but it was more cyclical and wasn't necessarily, there wasn't, a white government, basically. So as a result, because the British were able to go, well, it's terra nullius, they were able to say the logic of that call basically says that it's empty land, the colonizer is able to import all of their laws rather than needing to create a treaty with the relevant government and then work that way. So as a result, all British laws were basically imported to Australia. It is mostly all decided by the Brits. It's a bit wild, wild west in Australia initially, obviously. But by 1823, we have some type of a court system. It's not super equitable, it's not super well structured, but it basically gives us in New South Wales a Supreme Court that can fill the same role that the courts in the UK do. And that expands from there. The Governor of New South Wales acts more as a legal figure. We're able to then bring in a Governor General, and we kind of set up a more fully functioning colonial government, using the UK as inspiration. Our main legal development, however, occurs in kind of 1890 through to 1901, when Australia federates. And we're going to discuss that in a little bit as well in the public law section, but that's basically where Australia agreed, the people and the states, with some bargaining involved, agreed that they would no longer be directly ruled by the Brits, and then instead set up their own system. And that setting up of our own system is where we start to not just borrow from the UK and use what we already have, but be inspired by American independence as well. So, ideally, the courts now work in harmony with Parliament in terms of different matters. So, you can think of the different ways our legal system functions as being like private law governs relationships between people, criminal law governing the relationships between the people and the state, and public law, or admin law being the second step of that, are governing the government, basically. So courts and Parliament, as I said, has a bit of a symbiotic process in that a Parliament might legislate a statute, someone might breach that statute, it might go to court either because someone will sue them or because the state will say, hey, you've committed a crime, get in here. The court then will determine what to do there. An outcome might be given, someone might appeal that, someone might appeal that one, and it really depends. basically, our laws can often come from prominent cases, but the most average expression of the court system is that case law and statute law work together ideally in harmony. There are all these types of interpretations, which we're going to get to, not in the next slide, in the next couple of slides, that say, like, what if there's a contrast or a bit of an incongruence between, like, our precedents and the statute or other stuff, and there are all these ways that judges are able to work that out. And this goes back to, which we'll also get in the public law section, this notion of a separation of powers. So the executive or the legislature and the legislature puts together legislation, the executive puts that into effect, and the court system is able to turn around and go, actually, let's figure out what this actually means and how this works in practice. So it's meant to be quite a nice system that works together. Not always, but that's what it's meant to be. And when I said there about either because the state or an affected individual brings it to court, and I said, put a sue, our civil laws are also enshrined in statute in terms of being able to define certain civil wrongs. Now, some civil wrongs are also then crimes, such as things like assault. That is a civil issue that you can sue someone for. And in fact, assault in a civil definition is actually different to assault in a criminal definition. The criminal version of assault in civil is called battery, which is a bit confusing and a bit odd, but that's because it's just developed. But other things you can sue for, negligence, whatnot, are also enshrined in what does negligence look like. The state's not going to step in necessarily unless it's criminal negligence, but they do have some guidelines. Primarily because in the late 90s, early 2000s, a bunch of people just kept suing people. There was this massive uptick in all this civil litigation, and the government was like, we've got to do something about this. So that's how that developed. So often legislation can respond to a social need, which we see quite often, right? Some things, and we'll get to this in the criminal law section, laws are often very much based on what the legislature or even indeed society thinks is moral at the time. And laws will constantly change and regulations will constantly change depending on what becomes needed, or we are given more evidence to suggest something, or all those types of things. Law is very fluid, basically. So if we look at our court system, it looks a bit something like this. This is specifically related to this side, New South Wales, as you can see, in terms of civil jurisdiction, but it is the same structure as I'm going to show here. It's the same structure basically across the board nationally. The exception might be the NT and the ACT, because I'm not 100% sure how territory courts interact. I know they do have ACT Supreme Courts, but I'm sure it's the same. They've got local courts, but I don't want to definitively say that. Most cases will start, or a lot of cases will start at the local court or the magistrate's court. So these are the typical ones. You got local Rye Court, Manly Court, wherever you go, basically. They tend to be small. These matters in the local court are not serious comparatively. So driving offences that don't necessarily cause harm will go to the local court. In drug possession, again, provided it's not too serious, will go to the local court. Civil jurisdiction up to $100,000 in New South Wales will also go to the local court. It's all about the local court or the magistrate's court. A magistrate sits at that court. They're not called a judge at that point. And then as we get more serious, we work our way, or more objectively serious, we work our way up the chain. The other things that are often heard in local courts, not to diminish the seriousness, are more administrative matters, in not an administrative law sense, but in the sense of being bureaucracy. Things like ADVOs or AVOs will go through the local court initially, which probably says a bit about how our society treats those offences, but we shan't dwell on that at the moment. If you want to do that, you could do feminist theory, hey? Moving up from that, we have our district court, and that's where we might get a bit more bigger crimes, basically. Some crimes that are causing more harm that need a judge to determine. Or alternatively, if an outcome is handed down in the local court that a accused doesn't like, they can then appeal it to the district court. The district court will only still have the one judge. It's not quite at the point of being a really big deal, I guess. It's still a smaller court, but it will deal with issues of, say, more harm caused as a result of the crime, or as it says there, civil jurisdiction up to about $750,000. From there, you go to the state Supreme Court. Appeals can go up there. Tribunal appeals, so from not the Administrative Appeals Tribunal, because that's nationally, but things like VCAT for Victoria, things like that, that will go to the state Supreme Court. There are 3 judges on the no, that's the appeals court. Sorry, getting mixed up. There's still one dude, but there's lots of judges, and there may be a sense of once you go up there, you go to the next level of the Court of Criminal Appeals or the Appeals Court, which will then give you 3 judges, and if you still don't like the outcome there, you can go up to the High Court. But the state Supreme Court tends to deal with very serious criminal jurisdictions. Murder tends to get you up there straight away. On our adjacent side, we have the Family Court, the Federal Court, and the Federal Circuit Court. The Federal Circuit Court is where initial kind of appeals from tribunals will go to. So if Centrelink's made a decision or some type of immigration decision has been made, not immigration because that's complicated, but the NDIS, for instance, you might appeal to the Federal Court, the Federal Circuit Court. The Family Court of Australia is a very separate jurisdiction, which you will only really start to learn about if you pick that as an elective. And then up at the top, we have the big boys and girls on the High Court of Australia. So the first time we actually have more women than men on the High Court, which is amazing. Girl power, etc., etc. The High Court has ultimate jurisdiction over constitutional matters, over Commonwealth legislation, over certain appeals from tribunals and other administrative laws like immigration law, and they're also the final appellant jurisdiction. Now, what that means is you cannot appeal beyond the High Court. Once they give you your outcome, and there's 7 of them, so they can all write a little message, that's it. We used to, up until I think about the 80s, you could then appeal on to the Privy Court and go to London and then plead your case above there, but we've kind of said that, we may be a part of the Commonwealth, but we're not really needing to defer our legal authority to England anymore. So that is how roughly the system works. This one's a little bit cleaner. I just want to show that because I think it's a bit nice in terms of state and federal. And this one is good because this graph is good because it also includes the Children's Court and the Coroner's Court. The Coroner's Court is a bit different because it's inquisitorial, not adversarial. It's about investigating, and it's not necessarily bound by rules of evidence. What that means is things like hearsay aren't necessarily a thing because it's about investigating things, and then the Coroner's Court may refer on to another court if they think there is evidence for criminal charges. The Children's Court, as the name suggests, is for children under 18 unless it's a serious indictable offence. An indictable offence is an offence that carries jail times, as opposed to a summary offence, which is, say, parking or other vehicles, little vehicle issues, speeding, etc., etc. As I mentioned, the Supreme Court has original jurisdiction. That means generally it holds power over murder trials. Then you can appeal up to the Criminal Appeals Court or just the General Court of Appeals, and then you can go up to the High Court, as I said. Yeah. Okay, so moving on to statutory interpretation, which is basically what a fair amount of your law subjects will use, especially when it involves statutes. So things like criminal law, public law in terms of the creation of laws, not so much torts, and your kind of intro subjects. And then when you get more into advanced subjects, we'll use statutory interpretation, which is basically the process of having facts and applying law, those facts to a statute and figuring out what that statute is actually telling you to do. For now, when coming to statutory interpretation, you want to think about 3 rules. The literal rule, the golden rule, and the mischief rule. The literal rule is about what's the actual meaning of the text. It's generally the first thing you want to do. You don't want to try and read too much into a statute. You want to think like, what's the actual meaning here? Now that doesn't mean seizing on one word in isolation. It means assessing the meaning as a whole. But basically that is all about like what is actually being said here. The golden rule comes in as to whether the literal rule will result in absurdity. So is it completely absurd to interpret this rule in this way, and therefore step in and go, okay, let's make sure what we're trying to do here makes sense. Finally, the mischief rule is also sometimes called the purposeful rule, which is what mischief was the law trying to remedy? What is the purpose of this law for Parliament? What have they done? Why have they done it, basically? The precedence for these types of rules is a bunch of doctrine, and they go back to the UK. But the one you'll use a lot, especially in public admin and when you first start looking at statutory interpretation in your first unit, is Project Blue Sky versus Australian versus oof. Let's talk about that for a second. That's not how you say that. As if any of you've done legal studies, you're probably told, oof, ooh. As you can see, I'm in my 4th year and I'm still pronouncing that. If you watch American legal TV shows, they will pronounce that as verse or verses. Because that's the traditional thing, right? Football games, etc. There are 2 ways that this should be pronounced, and let's talk about that for a second. Depending on if it's civil or criminal. If it's criminal, it'll say RV so-and-so. And if it's civil, like in this case, it'll be so-and-so, so-and-so. Now, if it's criminal, let's do this. I've discovered I didn't discover, I obviously knew it existed, the writing tool in PowerPoint, and now I'm obsessed with it, despite the fact that no one wants that. Civil and criminal. Now, this is pronounced as against so-and-so. So R being here, no longer Regina, Rex, or also known as the king against so-and-so, or so-and-so against the king if it's an appeal. Most cases you'll look at this point are Regina, because, we had a queen for quite a while, and it'll say so-and-so against the queen. Civil, it's pronounced and. Project Blue Sky and Australian Broadcasting Authority. So my mistake offers a little tangent, a little learning moment there. Do your best to try and sort that out, because as soon as you sort that out, the more it'll be a habit, and you won't be like me still in 4th year using V instead of what it should be. Now, no one's going to get mad at you. It's really not the end of the world, unless you're, say, in a moot. If you're mooting, you want to get that correct, because the judge will almost certainly not be happy with you. But the case you'll use the most in terms of statutory interpretation is Project Blue Sky and Australian Broadcasting Authority, also just known as Project Blue Sky. The matters of this case was about if basically 2 contradictory statutes can exist at once. So the Australian Broadcasting Authority is the authority that determines what's on TV in Australia. They put out kind of a law, I don't know if it's a statute or if it's an explanation or something like that. Basically said a requirement that basically said the majority, or not the majority, at least 50% of content on Australian channels must be Australian. Now, the other aspect of the Australian Broadcasting Authority is existence was that they had to ensure they complied with all international treaties and stuff like that. Project Blue Sky is a New Zealand TV company, or was a New Zealand TV company. I don't know if they still exist. And they said that the ABA's memorandum that they were going to have 50% of Australian TV breached a treaty that basically had New Zealand getting dibs on Australian TV, basically. I can't remember the exact facts, but it was basically, you need to adhere to treaties. As a part of a treaty, we have TV rights, but now you've said those rights may not exist. So what is our outcome here? And basically what this case determined is that the provision must be construed or constructed so as to be consistent with the purpose of the statute. So kind of the mischief rule there. The term they use is they want to progress harmonious goals. So it doesn't necessarily mean that something will be invalid because it's contradictory. It's your job as a fact finder to be able to figure out how they fit together. Now, if that seems like a lot, don't stress. That is more something you'll need to worry about as you get further into public law, admin law. When you first look at statutory interpretation, it will very much be like, here is a law. Here is a second reading speech that a member for parliament has given explaining, should this case be prosecuted? And it'll be a lot more straightforward initially. They're not going to throw you in the deep end without any type of life jacket. They will ease you into it, don't stress. Law teachers aren't that mean, I promise. So, connected to statutory interpretation is legal reasoning. And legal reasoning is the most common skill you will use. So it's helpful to try and get a head start. At least one assessment, as I kind of mentioned, every semester or term will probably involve some type of legal reasoning. A wacky scenario, and then you need to demonstrate what you've learned from the course. So you want to think of it like you're a paralegal or a baby solicitor who's been given a client, and your boss has said, okay, can you tell me how to, depending on what side you're on, tell me how I can prosecute this person, tell me how I can defend this person, or just generally tell me what's going on here. There's a lot. Your marks in this case will not come from being right. It doesn't matter if you go, oh, this person did an assault, therefore they'd get 3 years in jail. That's not how we law school. The point of law is that it is not a black and white subject. So if you want no ambiguity, you better get used to that. But it's about applying the laws to the facts and being able to say, here is a precedence, or we can distinguish these facts. So similarities and differences. So for those of you that really enjoy logic and kind of figuring out a problem, this will be really great. For those of you that don't so far, that's okay. It can be a bit hectic at first, but it becomes quite logical. So the important thing with our legal reasoning is all about going, here is my opinion, here is how I can support it, basically. And the reason why this is important as well as about not being right is that that is deliberately so. Most case studies you get in law will be kind of drop of a hat. You could probably argue either way. Some might be more right in terms of some might be a more obvious conclusion to reach, but generally either side could be argued successfully. And it's about how successfully you do that arguing. Okay, the structure you will use is something called IRAC. And there is another one that's quite similar, but I can't remember the acronym. IRAC, maybe? MIRAT. Yeah. Material facts issue. So that's the other one. IRAC tends to be a bit easier to remember. The only difference here is that IRAC is issue, relevant law or rule, application or apply to the facts, conclusion. MIRAT is material facts, so the circumstances, issue, rule or relevant law or resources, argument, reply law, and tentative conclusion. That's really just a functional difference. It doesn't actually matter which one you pick. Most law schools will maybe teach you both, but IRAC tends to be the one that most law schools go for. This resource I've stolen from RMIT, for instance. So basically, as I mentioned, this middle bit, the relevant law and applying the relevant law, like explaining and applying the relevant law, is where you'll get the most marks. Obviously, you still need to pick out what the issue you're discussing is. If you pick out the wrong issue, it's going to be a bit hard. But even if you picked the wrong issue and then really explain the heck out of it, your teacher's still probably going to go, well, they've done a good job. And your conclusion, because you're going to apply to the facts and have an argument, your conclusion is kind of just restating it. You won't be adding anything new in the conclusive section. Basically, it will look a bit like this. So let's have a look at this one. This is again stolen from RMIT. As you can see, the colors do not match up, and that's really annoying. Ooh, that's annoying that they've switched that around. So our issue at hand, or this issue is a bit odd, which is why I cropped it out, but just as a bit of an intro sentence, the Neros will very likely be able to prove hostility through poor mistake because they honestly believed they own the disputed property. So in my case, I would say, it's like okay if you're writing an essay, but you probably want to make this something like, will the Neros be able to rely on pure mistake due to, or the issue at hand is whether the Neros can rely on hostility through pure mistake due to their genuine belief they own the disputed property. Then we move into the rule. So as you can see, there's a rule and then we've expanded on it. So the pure mistaken belief is one without conscious doubt. We've got our little reference there. If plaintiffs are made aware they may not own the disputed land, conscious doubt exists and the plaintiffs cannot prove hostility. In Davis, the plaintiffs proved pure mistake by establishing they had walked the fence line before buying the land and as a result honestly believed the fence line was property boundary. However, a plaintiff who thought the land was all ours but did not know the fence was actually the boundary would not be able to rely on pure mistake. So look, don't stress, I haven't done land law, so that doesn't make sense to me either. But basically we have our rule here, which is our pure mistake is one without conscious doubt. Conscious doubt can include being told they don't own the disputed land even if they don't believe it, or not making correct inquiries to determine if they actually own the land. The Neros will be able to prove they honestly believe they own the land and therefore the use was hostile. The Neros, like the plaintiffs in Davis, toured the property and believed the statements of their realtor that the property line was different. The Neros did also not have doubts regarding their belief, unlike the plaintiff who testified in Mid-Valley Resources. Explaining her problem, Mrs. Nero explained that's part of our land. She seemed convinced the disputed property belongs to her. The Neros made a reasonable and honest mistake regarding the property line. Therefore, the Neros should be able to prove that their possession of the land was hostile. So, you can kind of see how it links. We've got, here's our rule, here's the vibe, here's our facts. We can have a comparison. As you can see, there's lots of comparison about like the plaintiffs, unlike the plaintiffs. So that's, here's the precedents, here's our distinguishing, and that's how it works. This is using American laws, this second one, but it still uses the IRAC structure. Let me just check this. So here we have our issue. It's a lot more straightforward. It's a bit odd because it's phrased as a question, but that's okay. Under Washington, D.C. law, is Matt Keegan liable for plaintiff's injuries under theory of negligence, blah, 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 blah. Now we have our rule. In Washington, D.C., a driver who's suddenly stricken by an illness is not chargeable with negligence. This law comes from blah. In the Court of Appeals of the District of Columbia, which held that a defendant whose passengers were injured was not chargeable for negligence because he'd never fainted before and was in good health. They are the facts. We've outlined it, right? So we've said our rule here about, we've toured the fence line. There's a similarity there, right? The court reasoned that under those facts, the defendant did not know and had no reason to think and therefore should not be held responsible. Here, like the defendant, we've used that key phrase again, Keegan was in good health and never fallen asleep before while driving. Now, what's interesting about this example is that we have the plaintiff may argue. So we've offered kind of a counter argument, which they're then going to dispute. So we've said, however, we have a bit of a difference here than the given facts. So in the given facts, he did have a health condition. However, it was under control, so therefore we can't distinguish this case, basically. The court will likely rule that Keegan is not chargeable. The other thing you might be able to see here, and some law lecturers are funny about this, some are like, don't use, if it's a trust, don't say likely. And it depends on the case, but for criminal law, negligence, things like that, using, should be able to likely rule is a good habit to get into. Because it's not necessarily like a court will rule. It may not be the case. So likely rule just keeps that level of ambiguity, which is why Mirat has tentative conclusion. It's not 100% certain. Now, as you can see in this one from RMIT, we have a clear kind of, here's our source, here's another source, here's another source. We've got a few, we've got Falconer, we've got a bunch of sources that we've referenced. In this one, we have cite, which is quite funny. I don't know if that's a mistake. We have a source. We have another source there. So we're just using Cohen and Petty over and over and over again, but that's okay for now because that's what this is using. As you can see, though, every time they're making an assertion, they have to back it up. You need to do that as well. You can never make an assertion in the law without backing it up with some type of source. Judges won't, in their judgment, they won't just say something. They will back it up even if it seems silly. You don't have to necessarily take it to the extreme level that some judgments do, but you need to have sources. There are two types of sources that you want to use, which is primary and secondary. In research essays or to offer further explanation, your secondary sources might come in. Statutory interpretation especially will use secondary sources because even though secondary sources includes our traditional books, journal articles, websites, newspapers, law includes things like explanatory memorandums or reading speeches. Now what they are is they're a part of the parliamentary process that explain or help elaborate on why a law is being passed. So when you're looking at statutory interpretation and you get to kind of your third rule of the mischief rule, like what mischief is this law trying to prevent? And you might go, oh gee, I'm not sure. You can go to the second reading speech, which is when a law is tabled to Parliament for the second time. The member who's putting it forward goes, okay, this is what I'm arguing, this is why we should do it, this is what it's going to solve, this is why it's important. Now, you can't use that in a regular old legal analysis just because it's not relevant, but for things where you need to figure out what's actually going on, primary sources, or secondary sources, I should say, can be really good. Pardon me. Primary sources includes laws and cases. Common law, basically. Statute, case law. Simple as. When you're doing analytical legal writing, your reliance is on primary sources. Full stop. If it's not a case, it better be a statute, something like that. Don't quote the textbook. You want to have the exact reference. Now, your sources and referencing is derived from the Australian Guide to Legal Citation, Volume 4. You will probably buy a copy of this. I recommend it. It's really handy. The PDF is a bit convoluted online because you can't search and you can't skip to pages. So the book is spiral bound and it's really easy to use. And if you just bookmark a couple of pages, it's nice and easy. you will become besties with this little blue book. The reason for that being that it is very logical way of referencing. For those of you that have done referencing, you know, Harvard referencing, whatever before, there's like 7 different versions, right? There's like, sometimes you italicize this, sometimes you don't. And it's like, can we just get everyone together and figure out what the rules are? That's what they did for law, because of course they did, right? Once you get the hang of it, and maybe I'm just saying this because I'm a nerd, I kind of like doing my referencing. I remember talking to someone being like, oh, I think I'm going to join the editorial board this next year, which is this year now, of the Law Journal. And they were like, oh, but it's all it's doing is fixing referencing. And I was like, and that seems ideal. Like, I would love that. But it's a really important book. A chunk of it doesn't get used because it's like how to cite Hong Kong law cases. And it's like, okay. But for now, it's really good. Make sure you have a copy of it. It will be complicated initially, but you'll probably be doing a legal research unit quite early on, and that will help you learn this as well. This is basically the type of reference that it produces for case law. So you get the parties' names, Commonwealth and Tasmania, the year it came out, and then this is about where the judgment is located. So often when you're just writing in an exam, when you've got a tight word count or whatever, you can just go in Commonwealth and Tasmania 2013, or even in Commonwealth, which you wouldn't say, but you know, if it contextually makes sense, it works. This is about the citations for getting a printed copy of a case or whatever. So this refers to the Law Journal comes from, so that's Commonwealth Law Reports, volume 158, starting on page 1, and then generally there might be, if you're using, you know, if you're pinpointing, you'll then do like comma 22, full stop. So it's the Commonwealth and Tasmania case from 2013 in the 158th volume of the Commonwealth Law Reports on page 1 with a pinpoint reference to page 22 is what that means. Okay, let's get into private law now. Just checking. Oh, I'm disconnected for some reason. So, private law is all about governing. I know that says 6th grade, by the way. It's definitely meant to be like 6th form for the UK, and therefore us, not like year 6. Private law, as I mentioned, I'm using a very, very broad title, but it's the section of the law that governs interactions between people. So throughout your study, you'll look at things like land law, you'll look at contracts, business law, torts, trusts, all these types of things. Resolving civil disputes, these types of things. Now, that's a pretty broad range, and every subject is a little bit different. Just because you hate contracts, for instance, it doesn't mean you're going to hate trusts, even though it seems like they might be very similar. It's really interesting, this course, as a way of looking at how people are able to get themselves into trouble and how the law will still step in to protect them, I think is a good way of looking at it. So things like people suing the state or national parks or something for a lack of safety, and the government will still be like, yeah, fair, let's make it safer for you guys, even if they've done something objectively silly. And same with things like equity. So, torts is the OG field of private law. It goes back way into like 1100 type stuff. Our initial legal kind of foundation is this. So some of the cases you'll read is like, you know, someone comes up to someone with a sword and says, were it not the day of the Sabbath, I would stab you right now. And it's like, that's so divorced from our current context in so many ways, but it's still a key case that you will rely on. Not to the extent that you'll rely on its relationship to the facts, but that is a case that is about ambiguous threats, basically. Threats that rely on something else, and therefore, well, it's a Sunday, so he's not going to stab you. So therefore, not assault. A tort is defined as a legal wrong that one person commits against another that generally infringes on some type of legal right. Personal liberty, property, interference, these types of things. Generally, the remedy is compensation, as most torts are, or as most civil cases really are. It's about suing another that you have taken X from me, I want Y back. And the important notion to remember here with civil law is that it always intends to restore the victim to their place prior to the event. So it's not necessarily about like getting incredibly getting incredible benefit out of the case, although in some cases that would be regarding, say, punitive damages and stuff like that. But generally, it's about equalizing the playing field. The remedy, as I said, is compensation, though however some torts, assault and battery, false imprisonment, criminal negligence, can also be governed by the state and may result in further punishment if the breach of care or the events in question can be proven beyond reasonable doubt, which is a concept we'll get to at the end of the lecture. So, I don't know why that needed to absolutely squish the quality down of that image. So you'll go through a couple of different torts in your torts course, but the main one you'll start to study is the tort of negligence. Now, this is a classic case that it outlines it of Donahue and Stevenson. It's from 1932. This is a funny case, and if you ever you'll start to see a bunch of stuff in law to do with snails, especially when you do torts. This is where this case comes from. So Donahue bought a ginger beer from a store. I think. Yes. Donahue bought a ginger beer from a store. She drank it, or as it was being poured out, and then she realized that there was a very badly decomposed snail inside, which is gross. She gets really, really sick. She ends up basically getting food poisoning from the snail in her ginger beer. Now, she wants to sue the manufacturer of the ginger beer. Now, this is a bit hard, to sue the company that manufactured the ginger beer. Now, this is a bit hard because she didn't have a direct contract with them, so there's no breach of contract. So she didn't go to the factory and buy one directly from Stevenson. She got it from a cafe, and now she could, I guess, sue the cafe for breach of contract in terms of delivering an edible or a consumable product. She wants to try and get compensation from the big guy up the top who let a snail get in the drink and get bottled and get sent away. This case determines that even if there isn't a contract between people, you may still have a duty of care to your neighbours. So we can then see it's very 1930 as it, takes a lead from like Christianity in terms of, caring for your neighbours. But this is the famous section, which is, who then in law is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called into question. You must take reasonable care to avoid acts or omissions that you can reasonably foresee would be likely to injure your neighbour. Now, law is very fluffy with its language, so we've obviously got use of like reasonably foresee there. So, i.e., a manufacturer of a drink doesn't have to reasonably foresee something absolutely freakish happening. But you can probably reasonably foresee if the warehouse isn't clean, someone might get sick when they order your food. So this is the principle of negligence and the primary principle of what a duty of care is. This is then expanded through statute, especially for specific duties of care, like between specific classes, like doctor-patient, blah, 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 blah. But this is our main principle that you'll start with. And as you can kind of see, it's very much a iconic line. I remember when I first learned it, I said, we're doing torts at the moment. Donahue, I said to my uncle, who's a lawyer. And he was like, go on, tell me what the line is. And I was like, you got to take care of your neighbour. He was like, no, what's the words? And I was like, man, I don't know. But a lot of people know these words off by heart, especially if they learned law a little while ago. Now, these memes obviously created at the peak of the pandemic. I was doing torts when the pandemic started. So I was like, haha, remember when this was a thing? My law lecturer showed us something like this because she thought it was very funny. So I figured I'd chuck that again. But yeah, very key aspect. So to prove negligence then, we need to do a few things. We can't just say like, you did a duty, you had a duty, that something bad happened, right? And therefore you should be held responsible. To prove negligence, we've got kind of four main elements. A duty of care, as we saw in Donahue, a breach of that duty. So this can often be hard to prove, and depending on the field, there may be more protection. So for instance, for medical negligence, there's a bit of a higher threshold. And I'll get to that in 2 seconds, so let me just finish my train of thought. So a breach of duty, it has to be a foreseeable risk and an ordinary person would have taken precautions. So as I said, it can't be an absolute freak of nature. Like some massive storm comes and like there's let's say you're in a building, there's a 9-point magnitude earthquake or something and something gets broken. Probably not reasonably foreseeable if you live in Australia. Well, if you live in Japan, maybe, yes. If the risk is obvious, like that's a defense, i.e. that you have willingly accepted a risk as a victim. Now that is sometimes also doesn't work to an extent, so that governs things, certain injuries in sport, for instance, but may not govern like very violent injuries. It's a little bit clunky, that point. So it has to be a breach. The breach has to be foreseeable, but not too foreseeable, but not too foreseeable, So you'll get to that. The point is that it has to be a breach of that duty outlined in Donahue that a reasonable person would have seen could be a potential. The simple element, an injury has to have occurred as a result, like there's an injury somewhere. And most importantly, that breach caused that injury. So there has to be causation. Now, there are a couple of tests that do. One is the but-for test. But for the breach of that duty, the accident would not have occurred and therefore the injury would not have happened. It's quite a traditional way of phrasing it. But the alternative is there can't be a novus actus intervenius, an intervening act. So, as I said, if there is some type of freak storm, that's probably an intervening act. It breaks the chain of causation and the breach can no longer be connected to the injury that occurs. So one of the famous cases in this regard, and I can't quite remember the name, actually I can't at all remember the name, is a case of, I'm not sure where duty of care comes into it, so it might be more generally causation, is that someone, say, locks someone in a room, there's a window, but it's on the 3rd story. This person is being threatened, they want to get out, they jump out the window, they break their leg, they try and sue the person. The person who locked them in the room is like, okay, cop me for false imprisonment, sure, but like I didn't put a gun to their head and make them jump out the window. That's obviously an intervening act. You chose to jump out that window. Now, obviously, there's still a pretty clear chain of causation there. But for being locked in that room, the person wouldn't have jumped out the window. So that's how you can kind of figure that one out. A case which is it's not topical anymore, but there was a TV show, if any of you saw The Girl from Plainville, what's her name? Elle Fanning played her, which is about the so-called texting suicide case. This kind of tested the notion of causation and intervening acts, and it was said that there was an intervening act that someone wanted to stop harming themselves, and then they were kind of coerced back into doing so, and therefore there was a break in causation. Other torts include false imprisonment and assault and battery. So false imprisonment has some set elements again. The defendant must be restrained directly against their will. So, i.e., there's a positive, involuntary, I think. There's a positive action by the defendant. That should not be defendant, actually. I'm lying. It should be P. Plaintiff. Sorry about that, I got mixed up there. So the plaintiff must have been restrained directly against their will. So there has to have been a positive and voluntary act by the defendant to do so. So the defendant can't have been forced into engaging in false imprisonment, because that's not fair. They're not the mastermind there. And there has to be a positive act. So they can't just be like chilling there and someone goes, hey, you're imprisoning me. The other key thing here is it has to be against their will. And that doesn't necessarily mean, they agreed to it, therefore they went along with it. But if you say engage in this case, Balmain Ferry Co. is the case, where a person had gone in, went to catch the ferry left, they wanted to get out, they had to pay to get out. Now they had clearly entered onto the wharf of their free will. It was no longer false. It wasn't false imprisonment because they chose to be there. The plaintiff must be restrained in a fixed area, i.e. it can't be Australia as a concept. However, it can also be a psychological restraint. You don't have to physically be in a cage. It can also be the threat of a copper kind of watching you on a bench. In theory, you could get up and run away, but there's still that threat there. The other thing is total restraint is needed, either psychologically or physically. Someone standing in your way on a road when they could just walk around you is not false imprisonment. Unless, as I said, there's that threat involved. Battery and assault are also connected. As I kind of mentioned, that they're both in criminal law just called assault. Battery is actually the physical action of attacking someone. Assault is the threat of attacking someone. So battery, an attempt at battery is probably an assault. A failed battery may still be an assault. First off, there has to be a positive intentional act. There has to be an intention to either threaten someone or be reckless in that nature, or a positive or an intentional hitting of someone or any other thing. Intentional here, and in most law cases, also refers to, you should have thought that someone would interpret it in that way, i.e. recklessness. You either intentionally did it or you were reckless and you should have known that someone would interpret that as intention. Positive is also quite interesting here, in that it can't just be you chilling, like someone comes up to you and bumps into you and it's like, oh, you just batteried me. However, inaction can sometimes be a positive act. So there's a case, and as I said, I can't remember the name, because this is way back to year one, where someone accidentally rolled onto someone's foot with their car and crushed it. Now this person was like, get off me, you're crushing my foot. And they said, nah, and got out of the car and left the car there. Now, initially, the act of rolling the car onto someone's foot isn't necessarily battery. It could be an accident. There's no intention there. The act of continuing to leave the car there, even though, ironically, it's not positive, you're not doing anything, it's positive in the sense that there has been a decision made to do something. In this case, do nothing. Battery is about a positive intentional act that causes contact. Assault is that causes a reasonable apprehension of harm. I'm gonna get you. May be too vague. Actually, there's a case that determines that vagueness is okay if there is that reasonable threat. So that's what those two are. Okay, moving on to another aspect of civil law here. Contract formation. Contract is a formalization of civil relationships. A formalization of civil relationships. You may cover contracts over multiple terms, and it's probably one of the only, I think, subjects that kind of you need to kind of keep the stuff in your brain. With other ones, like with torts, you can, to an extent, you do the subject and then are like, okay, bye, torts knowledge. Contract will come up for a few subjects. So just make sure, keep that in mind. It doesn't mean you have to work on your notes over the holidays or anything like that, but it is something to remember. Within this subject, you're probably going to be asked a couple of things. Is a contract valid? Was it validly formed? Is there actually a contract? Have certain terms been included correctly? Has there been a breach of contract? What are the consequences of this breach? Our 5 main elements of contract, these being put in brackets because while they're still important, we don't necessarily check them off every single time unless there's an issue. Offer, straightforward, right? There's an offer of, hey, I want to make a contract with you. Do you want to? There's an agreement. Yeah, I'll make a contract with you. There has to be an intention to create a contract, i.e. you can't just sign something and then someone's like, haha, got you, signed it. So, i.e., hey, do you want to make a contract? Yes, I do. I want to make a contract is a good way. That's intention, right? Consideration is where you get a little bit funky. So consideration is also known as the quid pro quo step. Now, what this means is this for that. So you can't just say, hey, I'm going to give you $50,000. That's it. That's for funsies. Do you want to make it in contract of like, I'll give you $50,000? That's not enough. That's not a thing. Now, the consideration has to be kind of equal. Like it can't be like, yeah, sure, I'll give you $1 in return. That is just a gift. It's governed by different principles. Consideration has to be some type of this for that. I will pay you money and you will mow my lawn. I will pay you money, you will give me a gift, like a product. I will order it online. That's all quid pro quo. So it can be service, it can be physical, generally will involve some type of money when you're looking at contracts type thing. There's also certainty, which is both parties are aware they're making the contract and they know what the contract is about. It can't be too vague. There has to be a clearly like, this is what the contract is about, this is our terms, this is our subject. Those next 4 little things, legal capacity, consent, privity, legality. Legality is straightforward. You can't make a contract for something illegal. I mean, you can, but it's not going to hold up in a court of law. Or also you might go to jail. So there are 2 versions of this. Obviously, the first is like, I have a contract for a hitman. Is a problem all around because, you know, not great. The other thing could be, I am going to sign a contract, quite common one. I don't know if you're doing contracts or torts, but it's relevant regardless about certain amounts of, I've signed a contract here that you get to harm me and I'll enjoy it kind of thing. Now, no, like you could say that's like a consent thing and it tends to be discussed when we get criminal law, but it's a similar thing. If it's like, I am going to contract you to be my slave, in certain circumstances that might be okay. I'm not going to get into the logistics of that type of stuff. But if it's straight up giving up your rights and possessions for some type of quid pro quo, that's not legal. Privity refers to the notion that the person involved in the contract is privy to the contract, i.e. you can't create a contract about someone else or on their behalf without them being involved. Consent, pretty straightforward. You need connected to privity right. You need to have consent to make a contract about something. Legal capacity is about the person making the contract or involved in that has to be able to be involved in that process. So can't have a child or can't have people that maybe are not cognitively as well. For a contract to end, we have some basic ones. Performance. Hey, I hired you to mow my lawn, you mowed my lawn, sick, the contract's over. By agreement, you're going to mow my lawn 4 times and you're going to mow my lawn 4 times. Okay, 4 times have passed, contract's over. Frustration is if something happens that cannot be repaired. You were going to mow my lawn 4 times, but now you've died. Therefore, you can't mow my lawn, the contractor has been frustrated. It basically says, it's fine, it's over, but there doesn't have to be a breach. Spicy ones include repudiation and a breach of contract. Repudiation refers to the fact that one party is unable or unwilling to fulfill their side of the contract. So it might be, I hired you to mow my lawn. I have a contract with you to mow my lawn 4 times, but you are going bankrupt. You do not have the ability to fulfill your side of the contract. I'm going to repudiate this contract. Breach is, I have a contract for you to mow my lawn 4 times and instead you've painted my house, for instance, maybe, which is a bit silly, but that's okay. The breach has to also be sufficiently serious for it to rise to it. So if it's, I made a contract for you to mow mow my lawn 4 times, and it's I've mowed it 5 times maybe? No, maybe not. 3 times, and I'll come back in a month because I'm going on holidays. That's probably not a really serious breach of contract, unless it says in the contract you can't go on holidays or something like that. The remedy for contract law is about loss. As I said, most private law attempts to put the plaintiff in the position they were before whatever happened, with the exception of punitive damages. So there is loss of opportunity and general loss, which is just regular damages. So that includes, I gave you money and now it's gone, give it back to me. Or I entered into agreement with you and you said you were going to get me heaps of exposure, which would have amounted to $50,000 down the track type thing. There's also specific performance and injunction, which are equitable remedies, which we'll get to equity in 2 seconds. Now, what that means is specific injunction stops you from doing something. A specific performance makes the other party fulfill their side of the contract. So i.e., I don't want my money back, I just want you to do it. Or alternatively, they have no money and they still just need to do it. Rescission is a way of basically stepping back to the beginning and undoing the contract from the very start. Saying, okay, we're setting aside the contract, it never existed. So there can be no breach because the contract has been disbanded, basically. Equity, as I said, sits alongside private law. It used to be 2 separate jurisdictions and now it's been merged. So you can simultaneously run a claim through common law and equity. This is about ensuring private dealings are fair. So if you have a contract and the contract, there's been no breach in that regard, but something is very wrong, that will be when the law kind of steps in and says there needs to be something here. This isn't fair. So some clear areas where this happens is unconscionability and fiduciary relationships. Unconscionability, our famous case is Amadio and Commonwealth Bank of Australia. Now this was the case where a child, and when I say child, like an adult child, got his parents to be the executor on a home loan for him. Or the guarantors, sorry, I should say, on a home loan for him. Now, his parents couldn't speak English, and they didn't really get what they were doing. So he went, yeah, no, it'll be fine. I'll pay back all my loans. Like, don't even stress. I just need our signature. It doesn't even matter. Don't stress. And they signed it. So they were like, well, it's our son. We trust him. We don't know what's going on, but, Now, he defaulted on his loans, and Commonwealth Bank came to collect. I don't know if he went bankrupt and therefore they went to the parents. And the parents were like, what? Like, I don't know what's going on here. This went to courts and the courts found that while, technically Commonwealth Bank was within their right to do that, it would be unconscionable because there's a clear disadvantage here that's happening. The other case in fiduciary relationships will be things like you can't derive a separate benefit from a relationship without consent. So if you're running a company with someone and you get some insider information as a result of working for that company, say, I know that a certain area of land has just been bought, so I'm going to open up my own firm or something there. Without my knowledge that I derive from my relationship, I wouldn't be able to be successful. So therefore, unless my boss says, yeah, go set up a new building over there, I've done the wrong thing by that relationship, even though it's technically not illegal. And same thing with being able to make money off of certain ventures where you're using your relationship with someone else or with business or whatever. Trusts you can think of as a bit like a funky contract with some more rules. So trust is about holding property under contract, basically, for a certain amount of time. What this means is that, there are some rules here, and what this means to create a trust is there has to be a certainty of intention, i.e. there has to be, much like in a contract, a clear intention to set up a trust, a certainty of subject, who does the trust involve, a certainty of object, it has to be identifiable, you can't like make a trust of vibes, so what is it that is involved in the trust, and full constitution or valuable consideration, which basically means the person creating the trust has to have legal right to what they're including on the trust, or have engaged in some type of consideration to allow that element of property to be included without their possession of it. Trust, you're probably not going to get to for a little while, so we don't stress too much about this, but I just wanted to chuck it in regardless. So trustees must also obey the trust terms as they are simply holding the trust property for the beneficiary. So then we move on to alternative dispute resolution, which is a little bit of a funky one. What this means is that to solve a civil case or a private case, you don't necessarily need to go to court. Instead, you can go through different methods. Negotiation, mediation, and arbitration are our main ones. And they include negotiation being where two parties meet to attempt to unify their remedies. So basically, we have two opposing goals. Let's see where we can meet in the middle. Mediation, it's a bit like negotiation, but there's a third party that will organize it. Arbitration is kind of like a court. There is a judge-like figure who hands down a legally binding outcome, but it's not public like the court system. So, using those three examples of in mediation, negotiation, arbitration versus litigation, which is the traditional court-based system, why might a company, a firm, a client want to go through alternative dispute resolution, use an alternative method instead of litigation? So I put up a little Slido at the moment that's just a brainstorm. Don't stress if you're wrong, right? Like there is no wrong answer, number one. All your thoughts are very valid. But why do you think it would be worthwhile to use an alternate method to resolve an issue instead of going to court? So just a little bit of critical thinking. And then we're going to go on a break. So I'm going to hold this poll open. I'm going to sit for 2 minutes while I see some responses come through. And then we're going to go on a little bit of a break for about 10 minutes. And then we're going to start on the second half, which is public law and criminal law. But why do you think, and then we'll also discuss the answer to this, obviously. But I'm going to hold for 2 minutes. See if we can get a response. Why do you think alternative dispute resolution might be favoured over general litigation? And if it's a bit difficult, don't stress. We did this in class yesterday. Like me, I did this, sorry, not yesterday, on Monday. We had this discussion. So someone's already said cheaper and quicker. Also private, so the company won't suffer from bad publicity. Nailed it. Pretty good, yeah. It is, sometimes it can be a bit, like, depends on who you like. If you're bringing in someone really fancy to be your mediator, it might be a bit more expensive. But it's generally going to be more efficient than the courts. And potentially we can have that privacy. Faster, yeah, probably. Possibly to save face. The possibility of litigation may involve media parties and unwanted attention, so an outside negotiation may be beneficial. Absolutely. It's a bad look, right? Or it can be a bad look. Less expensive, more time efficient, less media attention scrutiny, promotes amicable relationships. Yeah, that's a really good point. It's a less hostile, maybe not arbitration, but mediation and negotiation will generally be less hostile because you actually get people in the room and go, okay, let's discuss. And can reach a more favourable decision. And yeah, there is a possibility for things, especially like, as I said, mediation and negotiation, that you can kind of get to a neutral ground where both sides kind of get what they want. Whereas litigation will just like, okay, you're right, see ya. So yeah, really good. Really great thinking for the 4 of you that responded. Thank you so much. You can keep having a go if you would like to. So one case I think that's really relevant at the moment is the case of Sally Rugg and Dr. Monique Ryan at the moment. So if you can do a Google for those of you that aren't chronically connected to politics like me, that is a staffer of Dr. Monique Ryan, who's an independent in Melbourne, independent politician, says that she was unfairly terminated. Now, allegedly, I don't actually know, I can't remember. She filed a claim in, can't remember what court she claimed, basically wrongful dismissal. Now, that now then went to mediation because of the negative media attention, I think was the main reason, is everyone was kind of going, oh, you know, of course Monique Ryan's like working them too hard, of course she is, when people going, well, maybe she shouldn't have, you know, Sally Rugg shouldn't have gone into politics if she didn't want to work the long hours, blah, 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 blah. Not the point. But this all happened on Twitter, so it's not like there is a sense of logic going on in this commentary. It was then taken to mediation, I think, where they came to the conclusion that Sally gets to work a bit longer, ran out of time, and then we'll leave or something like that. So it worked out quite well. It had that better outcome and took it out in the media. But let's move into public law. So I kind of discussed at the beginning that the Australian legal system is very heavily based. I'm turning the brightness down on that. It's very aggressive to me. That the Australian legal system has been primarily based in the UK because that's what was imported here with colonisation. However, it's also very different to most other Commonwealth nations in that it takes the lead from America because it was properly, our government was properly set up after our initial legal system was set up. It's colloquially referred to as the Washminster system because it's a synthesis of ideas like federation, federalism, and a constitution from Washington, and responsible government and parliamentary sovereignty from the Westminster system. Now, our Australian legal system works as follows. The key to the system is a separation of powers. Now, what that means is that each element of government keeps the others in check and working correctly. Both Westminster and Washington have this within their system. It's a key system. But it's not just enshrined in our constitution in terms of giving us that, you know, the judiciary will be in charge of the high courts and may determine matters of blah, blah, and the executive may do X, Y, and Z. But it's also about parliamentary convention. Now, conventions come from primarily the Westminster side of politics. So the UK does not have a constitution. The reason for this is they rely on conventions and this notion of, as I said, responsible government. Now, what does that mean? Because it's pretty vague. And how can you, how can you even uphold convention? Like, you can't impeach someone for doing a convention because it's convention, it's not a law, right? Well, how this works is for the theory of responsible government that says parliament's a representative, and that means that if someone behaves badly and subverts conventions, the people will vote them out. That's what it relies on. It's a little bit probably naive now, maybe? I'm not sure. It's a probably mildly flawed system, isn't it? Now, the flip side of that being obviously that sometimes constitutions become deeply disconnected from what they were originally meant to be seen as. So America being a strong example of this, there's about, a heap of amendments to the Constitution, and, there's the controversial ones about, Second Amendment rights, which may not be as applicable today as it was when it was created with muskets in mind. But responsible government is about the fact that the people have power. Parliament is the representative of the people, and that's where parliamentary sovereignty comes from, which is a UK concept, i.e. Parliament is more important than anything else. Representative Parliament, that being, which is important in the UK because they have two houses, but one of them is not a representative house, it's a House of Lords. Now, we can see there's quite an immediate example, I think, that comes up in regards to responsible government in terms of being a convention that's upheld, is it does rely on the people being aware of things that have happened. And I think there are two pretty solid examples of this one, and one didn't need to go to an election because it happened at a point. The UK has elections, I think, every 6 years, or at least they're meant to, so wouldn't have come up to an election. Is the party scandal for Boris Johnson. If the people hadn't known about that, even though potentially he breached some type of convention, the convention in this case is just like being a decent guy, people may not have known about it. And then how can you say responsible government works if the people aren't aware? Now, I think the most pressing example of this is the current big issue, that's probably Australia's second biggest constitutional issue since the 70s, which is the issue of former Prime Minister Scott Morrison swearing himself into multiple ministries. So for those of you, again, that aren't chronically online or into politics, we found out not long after the election last year that Scott Morrison, during the pandemic, made himself Treasurer and Minister for Health and Minister for Environment and all these things. He only used the powers once to stop a offshore oil rig. Ironically, a really, really great thing that now has to be undone and go through it again, which is annoying. But that is, and quite often what was said is the commentary was like, this is a severe breach of our Westminster heritage and, of responsible government. And I'm sitting watching the news and going, I know what that means. But that's another thing. That only came out after the election. Had it come out before the election, I think everyone would have gone, oh yeah, that's not responsible, let's vote him out. Had he been re-elected, we probably would have never found out, which is a bit of an oof in that regard, in terms of responsible government. So it relies on knowledge of what's going on in government, basically. Now, as I said, that's kind of how we uphold conventions. The interesting thing here is that also that Australia's legal system, although it relies on the separation of powers, isn't technically separate to the extreme that America is. So in America, you obviously have your houses of government, your Senate, your House. You have your president, who is represented, comes from a party, but he's not elected as a representative of that party. He's elected as a dude. Joe Biden was elected because he's Joe Biden. And then you have Joe Biden's ministry of all his executive, which is, the Secretary of Defense and blah, blah, blah. And that's people he's just picked. In Australia, we obviously have slightly different in that our executive comes from our legislature. So Anthony Albanese is the leader of the Labor Party. We don't vote in Anthony Albanese, you vote in the Labor Party. And his ministry are members of the legislature. So there's a slight overlap there, which I don't think is necessarily a bad thing, because I think that enshrines that notion of responsible government. If someone acts really poorly as a minister, they're probably going to lose, they're going to get booted to the, they're going to get booted to the back bench. But it is an interesting thing to consider. And you can also see the judiciary is involved there. The other interesting thing to note, just to go in a bit further, is obviously our constitution. Our constitution is a bit vaguer than the US Constitution, which I think for all intents and purposes is a good thing. I discussed what responsible government means. I'm going to discuss a little bit more about federalism and parliamentary sovereignty. So I briefly mentioned parliamentary sovereignty. It's basically the idea that because the people elect parliament, now this is a UK notion because, as I said, they've got two houses. Because the people elect parliament, the House of Representatives should take precedence over the House of Lords in this case. So the House of Reps could do whatever they want because they are the more important ones. Now, in Australia, that poses a bit of an issue because our House of Representatives is not the only House of Representatives in theory. We also have the Senate, which is also elected. So we have a bit of tension here because there maybe as a whole parliamentary sovereignty over the executive maybe, but the Senate isn't more, it would be untrue to necessarily say that the House of Representatives is more important than the Senate. Technically, the Prime Minister in the UK and Australia gains their power from the House of Representatives. So whoever has the most seats in the House is elected government, the governing party. The Senate isn't included in that calculation. So technically Parliament, in the sense of the House of Representatives, has sovereignty over the Senate, but it's a little bit of a tricky issue there because they both are elected. They're both meant to be serving out the will of their electorates or their states. So you do get a bit of an issue here. This issue comes to a head, and we're going to discuss it in a second, during the dismissal of Gough with them, which also reflects this second one. So we have parliamentary sovereignty, that refers to the House of Reps. Federalism deals with the Senate. So federalism refers to, now this can feel a bit confusing because we have our federal government, which is kind of like national government, right? Federalism in this case, from the American system, refers to states. So we know in America, they take federalism to the extreme in that the states' rights are super duper important because they've gone to war heaps. They'll go to war heaps about it. And it's obviously very topical at the moment with things like a women's right to choose, and we've also got these issues currently with other laws that may revolve around the vulnerable, like transgender people. So we have this disconnect in America between federals, the states, and the actual national government. The national government can step in, but like the last time there have been kind of 2 times the national government has stepped in and legalized stuff. The first time was slavery, didn't really end well. Second time was about the civil rights stuff. Probably only ended well because JFK had just died, right? In Australia, we don't take it to that extreme, right? Our states still ultimately have to adhere to high court rulings, just like the Supreme Court in the States. And generally, there can't be too much contrast between state decisions and what the national kind of memo is. Now, that can be, absolutely. And we've seen that, for instance, with the ACT at a point legalised same-sex marriage before any other state, and then when it was made wholeheartedly illegal at a national level, that overturned the ACT's decision, and that went to court. That was the whole thing. I don't know the specifics of that. I couldn't tell you the year, but it was quite a thing. I vaguely remember it. So we don't take it as extremely as America, but we still have this tension that our states have rights, but more importantly, our states are represented at our national level through the Senate. So the Senate works that states are afforded X amount of seats each, plus the territories get 2 each, ACT and the NT. It's meant to be equally represented. WA has the same amount of senators as New South Wales, so that New South Wales can't shout out WA issues. Because if it was based on population, you'd have the problem of New South Wales wants to dig up WA because they've got heaps of minerals, and the whole Senate's like, hell yeah, that's a good idea. And the single WA senator is like, no, maybe don't. So it's about protecting the rights. But now we have an issue in that the House of Reps is meant to be the representation, but we still have the states vying for their people. And this comes to a head, as I said, during the dismissal of Gough Whitlam, which we'll chat about in a second. So here's another little diagram from the government specifically about the judiciary, the exec, and the parliament. I'm trying to figure out if these are people or if that's just little cartoons, because I'm like, those ears do be looking like Tony Abbott's ears. But that's our... Maybe. I can think of people, but I might be reading too much into it. So judiciary, power to make judgments on the law. Parliament, power to change the law. Exec, power to put the law into action. Sitting alongside the law, as we've said, is admin law or public law kind of governs what a government body is allowed to do. In the criminal system, you can appeal a decision, or in the civil system, you can appeal a decision. But what about when a government body does something? So you have a Centrelink decision, an NDIS decision, and you think it's wrong. You don't want to sit and just take it. So the first thing you can do is about if you think it's the wrong decision, you can opt for what's called a merits review. So i.e. was the case decided correctly? This is reviewed by a tribunal, and generally the Administrative Appeals Tribunal, which is currently being destroyed and reset up because it's kind of fallen apart a bit. Ideally, it's meant to be an independent body that assesses whether the decision was correct. It's not I don't like this, fix it. It's they will then go through the decision-making process and see if they would disagree with that. Now, this has become controversial. I'm not going to get too bogged down in it. Members of the AAT are meant to be independent. Over the last decade, it's become significantly less so. It's kind of been a jobs for the boys endeavour, which is why it's being disbanded and set up, which is a good thing. But for those of you, when you study admin law, it will look very different potentially to when I studied it, which is pretty cool. If the AAT makes a call that you further disagree with, you can then appeal it up. Tribunal merits review is meant to be more informal. It's meant to be you can come, even if you don't speak the best English, you can bring a translator in. You don't need to have a lawyer. It's more a discussion, right? It's an investigative process about whether the right decision was made. This is contrasted to judicial review, which determines the legality of a decision. So you get a decision from the NDIS, for instance, or immigration, and you think it's just not just the incorrect decision, you think something illegal has happened or something wrong has happened in the process of making this decision, and the decision shouldn't even be valid anymore. So that becomes then a more formal process with a proper judge. Not that the tribunal members aren't proper people, but this is a legitimate, it goes to federal courts. So the judiciary in this case can hold the executive, the ones who made the decision through their delegates, to account. A decision can be challenged on the following grounds. So a fact-finding error, you just straight up got the wrong information. Unlawful delegation, a minister is meant to have made a decision but has instead not really done any of it. Someone else has done it for him and he's just signed a paper. The case of this is if you Google Alex Hawke, I think US immigration case. This is a case where he was found to, within a drive from Sydney to Canberra, so 3 hours, had simply made a decision on an immigration case that was quite complex. He did it in the car. There's a photo of him in the car signing it. And it was challenged on the basis of he obviously hasn't read that. And it was found that, yes, someone else has done the work for him and he's just given his signature. Procedural fairness is also a key issue. This is generally split into two: rule against bias and the rule of a fair hearing. A fair hearing says that an individual who is going to be impacted by a decision has the right to contribute to that decision-making process, either by putting information forward or something like that. So they have to be told what's being discussed, give them the opportunity to respond. Rule against bias is what it sounds like. You can't be making a decision that might be biased. Errors of discretion, if you have, or maybe that's the Alex Hawke case, I might be lying. No, that is not the Alex Hawke case either. So this is where discretion has been used incorrectly. So if the law is slightly flexible, you need to still be reasonable in that regard. So you can't consider something that has no bearing on the case, even if you're technically allowed to consider those things. Unreasonableness is about, was this decision, it kind of goes a little bit back into merits. Was this decision so unreasonable that no one should make it, basically? And then fettering discretion and jurisdictional error are slightly different. So jurisdictional error is a way of describing whether the error that's been made, be it unlawful delegation or procedural fairness, goes to the heart of the issue. Should the issue be invalid? And fettering discretion is also about, have you told someone else to do your job for you when you shouldn't have? So I'm actually going to skip this because I want to cover the criminal law and get to some questions. For those of you that want to get some prep on for your public law course, do a little bit of Googling about the Whitlam dismissal and have a think about why this case could really only happen in Australia. So why does this case of Gough Whitlam, the Prime Minister being dismissed in 1975, demonstrate that there's a tension in the Westminster system? So that's where federalism and the Senate comes in. The Senate being still representative, Parliament and the House of Reps still technically being more important, those types of things. Where does it come in? And also the very nature of a constitutional monarchy, being able to dismiss an Australian Prime Minister. Okay, let's do some criminal law now. That's also been compressed to goodness. This is kind of the one everyone thinks about with law, right? This is the traditional, like, let's get into the nitty-gritty, dirty cases, right? So criminal law, as I mentioned, is about the state governing its people. It's very interesting to get into a moral or critical reading of crime because it's generally, criminal law has an element of morality to it. It's about what society says should be frowned upon. What does society need to punish? So obviously things like murder and assault, they're not great. They're not ideal. But the moral limb of the law has also been incorrect historically. So I've put up there things like drug use being criminalized instead of maybe seen as a health issue, or even things like potentially more benign drug use like cannabis is illegal, but alcohol isn't. Now, you can also look historically at the things that have been illegal that now we look back on and go, oh, that is not a crime. So same-sex relationships or civil rights aspects have obviously all changed significantly. So crime is very much a fluid thing, like a lot of the law, as we're discovering over this lecture. So to make out a crime, there needs to be some elements proved, which we're going to discuss about, but even though there's not a slide. But even more important to an extent, even before you can get into the courtroom, is the notion of criminal responsibility. So for us, we're going to talk two things: age and awareness of a crime. So the first about the age of criminal responsibility is a very it's a very topical debate at the moment. Again, for those of you that I follow politics a bit. So the principal law is Dolly and Compax, which is that, the child cannot be evil, basically. So it says that a child between the ages of 10, which is the age of criminal responsibility in Australia, and 14 may not know the difference between wrong and right in certain circumstances and may not be held responsible. This is all made. It's a rebuttal presumption. So the prosecution has to say, no, the child didn't know the act was wrong, and here is the evidence to support that. It can't be, no, of course the child knows it's wrong. Stealing a car is bad, because, I don't think that case would, I think that would work. But it can't just be rebutted on the basis of the crime is severe. So it's also dependent on the age of the child. If you're, 13 and 9 months, it's going to be pretty easy to rebut Dolly and Compax versus a fresh 10-year-old. As I said, this is an area of debate at the moment for the raise the age movement. So it suggests that children should be diverted away from the criminal justice system especially when institutional biases are taken into account. So something like, every child in the Northern Territory in prison is Aboriginal. So we need to take into account what is the impact of these laws. So the ACT has said they will move that 10 up to 14, that 14 years of age will be the age of criminal responsibility. And a bunch of former New South Wales Attorneys General have recommended that New South Wales should raise the age to 12, which will be interesting after the election to see what happens there in New South Wales. So that's the principle in terms of the age of a child being a big deal. In terms of criminal responsibility from understanding the crime, it's also important that law cannot be just to find someone responsible for an act that they did not know was wrong or unable to understand was wrong. This doesn't mean someone say, oh, I didn't know that was a crime. Like, ooh. It means that someone physically or psychologically could not comprehend what was wrong. This original case is called McNaughton. It's the McNaughton standard. And this is an international standard. It's an old English case that's used in the States. Still, it's used over here. It's obviously developed. There are more modern cases to use now, but this is the traditional foundation to establish the old defense of insanity. So it said it must be clearly proved that at the time of the committing of the act, the party accused was labouring under such a defect of reason as to not know the nature and quality of the act, or if he did know it, that he did not know that it was wrong. So there are two issues that you prove one or the other. So, however, it's often kind of seen in the media that like this is a get out of jail free card, that it's like, okay, like cool, I did it, I didn't do it, woo, free me. A verdict returned is a verdict of act proven but not criminally responsible, and the offender will then be transferred into the care of the Mental Health Review Tribunal. So they'll be taken generally to a care facility, basically a jail but a hospital, and they'll be reassessed at certain points to be when they can be released from care. So often like this notion of like pretend you're mentally ill, which generally isn't successful, is not good for severe crimes because you will be locked up basically indefinitely. Now, if you're legitimately unable to determine right from wrong, that's the best thing for you and for society, but it's not really a cop-out card defense that people use, as much as crime shows like to talk about it. Now we move on to the burden of proof, which I mentioned a little bit earlier about beyond reasonable doubt. So the civil standard of proof is on the balance of probabilities. So if you go to jury of 6, you have to have been determined that, yeah, this probably is the case. It doesn't matter about the number of jury. I don't know why I was thinking about it that way. Criminal case is that it must occur beyond reasonable doubt. Now, that doesn't mean I can think of some insane explanation why, I have an axe in my hand and someone in front of me has an axe in their head. Has an axe mark in their head. Like, it's not like, oh, someone ran into the room, smacked them, wiped all their fingerprints off, drugged me, and then put it in my hand. Oh, officer, I didn't do it. That's silly. Like, technically, yeah, could that happen? But it's not a reasonable explanation. So any defense or alternative explanation to the events in question has to be unreasonable. Now, the classic case that demonstrates this difference between the criminal and civil standard is actually, I think, the O.J. Simpson case. O.J. was obviously found not guilty in a criminal court because his lawyer was really, really great at emphasising that there's doubt. The LAPD did do dodgy stuff. They did plant evidence. There is no way to know what happened. Now, let's be real. He did it. But there was enough reasonable doubt that could be cast that said, well, I guess this could be a setup. Contrast that to the civil case that Nicole Brown's family brought against O.J. Simpson, which was wrongful death. He was found liable because on the balance of probabilities, yeah, he probably killed her, right? So that kind of demonstrates the difference. Some two key recent cases in Australia. We have Pell against the Queen, so Cardinal Pell's case. The High Court one specifically explains beyond reasonable doubt really well, though still notes that the evidence was quite compelling, so kind of says that it's a very hard call, basically. And the Queen against Dawson, or Regina against Dawson. So that's the Chris Dawson case, which is the opposite in terms of the Supreme Court justice did an excellent job and a very long judgment, systematically saying someone offered this explanation that cannot be true. So again, if you want to read these two cases, I would really recommend it, if you would like to, and they'll help you understand some things better. Keep an eye on the Dawson case. He will appeal. I imagine that will end up in the High Court. Though it will be interesting because that was a judge-only trial in the Supreme Court, so it's a bit hard to say that the judge didn't know what he was doing versus a jury. Now, to look at a critical lens of criminal law, why do we have a criminal law system? Now, we've said it's to have a moral meaning, basically, to society. But the governments generally hold that there are 5 main reasons. Deterrence, for both the person that committed the crime to be deterred in the future or others like them. Punishment, to just straight up say that's wrong. There are consequences to your action. Protection of the community. Reform, to reform and rehabilitate a prisoner. And to denounce from a moral perspective. Society does not stand by this. Now, most crimes and punishment can be slotted into some category here. But there are some, as I mentioned before, because criminal law is quite often very fluid, sometimes there's ambiguity in cases where there has been a horrible accident, for instance, and someone has died, but it was accidental. Now, you might say, yes, deterrence is our main, it stops people from maybe making the same mistake, or it says that, that type of thing. But really, if someone's been in a horrible accident, they're probably punished enough. They're probably not going to commit a crime again, so they don't need the community protection. There's maybe no reform because, again, it's not going to happen again. So comes more cases that don't fit into one of these 4 will generally just be about denunciation or the moral meaning. So I think the word that New South Wales uses is protection, side deterrence, retribution and reform. I can't find the actual word that's often used. That's okay. Denunciation, yeah. That's the word that the ALRC uses. Someone else has used it, but that's okay. Generally, if it doesn't fit into deterrence, punishment, reform, or protection, it's generally denunciation. That's bad. You shouldn't do it. Which can sometimes feel a bit weak when, obviously, prison's not a very pleasant place to be if you're not a hardened criminal, or even if you are. So that's why there are things like not using sentencing, right? Sometimes you won't receive a custodial sentence. You'll receive, community corrections order. Before you get into sentencing, bail is a very controversial thing as well at the moment. It's generally used to protect the community or ensure that the accused is within the system. So if you think they're not going to come to the next trial. But it is ultimately incarceration before guilt has been determined. So for Victorian statistics, 50% of women in Victorian jails are not sentenced at the moment, and a percent of that have not been found guilty yet. And 51% of Indigenous people in Victorian jails are also unsentenced and may not have been found guilty yet. So in terms of there's a strong balancing act that has to happen with bail, with protecting the community, ensuring efficiency of justice, but also ensuring that people aren't in jail necessarily. So Bail is also an interesting flip on the usual criminal law dynamics. So normally the state bears the burden to prove beyond reasonable doubt, to prove why a certain sentence should be given, etc. Bail is actually the accused must prove why they should be given bail. What is the exceptional circumstance that says they should be sent home? And often, instead of if a person is released on bail, they might get check-ins or curfew or tracker, some type of something like that. The fact that the onus is on the accused, though, is a bit troubling when we get to the notion of unequal representation. So sentencing happens after that, after the guilt has been determined. Magistrates and judges and justices must take into account some elements. So objective seriousness, aggravating factors, so if the victim is a younger age, victim impact, the consequences of the crime, if the offender is really, really old, or if the offender has some type of terminal illness, and heaps and heaps and heaps and heaps and heaps more. They don't have to take into account every single one, but they need to have taken into account these critical factors. Some crimes have a mandatory term, which is quite controversial. Judges don't like it because it takes away their flexibility and much more American. Some states don't rely on that as much as well. The other thing that must be taken into account is if an offender has pled guilty, they can generally receive a % of time off their sentence to save court resources and encourage responsibility. So this is what the criminal law process looks like. I think it's upside down mentally in my mind. So you have an offence. There is an offence that has been committed. A copper could go, yeah, no, just don't do it again. Or it can go to the court. The court can say, no, you were acquitted, you didn't commit this crime. If it's a serious offence, it might be put up to a higher court, like a district court, or alternatively, there'll be a sentence. You may not appeal, it's $300, you might choose to cop it. It's 3 years in jail, you might choose to appeal that. Goes to a higher court, so you're either acquitted, sentenced, you can appeal, etc., etc. You can go all the way up. In theory, you can keep appealing it all the way up to the high court, which I assume we will see in the Chris Dawson case, and we did see in the George Pell case for 2, prominent ones. Now, I did say, I didn't leave it in the slides. Mens rea and actus reus refers to the mental state and the act committed. The majority of crimes will need to have both elements proven in order for the crime to be proven beyond reasonable doubt. Now, the act will generally be straightforward. It is either a positive act or an act or omission, i.e. you either did something or you deliberately did not do something that resulted in something. The state of mind, again, is generally will give the differentiation between certain charges. So, for instance, murder will have the mentality that you intended to cause severe harm, murder, or were reckless in not anticipating it would happen. So the case in that matter, there are 2. There's one where a guy drove his truck through, not a petrol station, like a diner, and he tried to say, I didn't realize anything bad would happen. And they were like, yeah, okay, but you probably should have. And the other side of that one about the act or omission, the case of Ebony, don't look it up, it's a bit grim. It's not a bit grim, it's horrifically grim, which is a child neglect case, is about the choice to not do something and that reaching the standard of murder. If we go back to the mens rea, the relevant state of mind, if you, for instance, didn't intend to and you weren't reckless, but someone still ended up dead, that's where you might move to manslaughter. So you generally have to have both. It's a really good way to visualize it, and I'm annoyed I didn't make the slide because I had a plan and then obviously it left my brain. A table is a great way to visualize it. Like, what's the crime? Manslaughter. Mens, actus, that type of thing is a good way of looking at it. Oh my God. Okay, I'm going to quickly zoom through some questions on Slido in our last couple of minutes. There aren't a heap, which is not fantastic, to be clear. Be chatty, guys. But sometimes I do a lecture and there's hundreds and hundreds of questions and I'm at the end going like, oh my God. So also, what are the pathways for solicitor, barrister, etc.? What majors would benefit those pathways? If you're doing law, in terms of electives, unless you're keen, like you want to go into a certain field of law, that's when your electives start to matter. Picking certain electives won't preclude you from becoming a solicitor or a barrister. They're two different streams. So when you finish your law degree in 5 years' time, you will do your practical legal training, which is basically like a certificate that says, hey, you can practice law. That's so cool. You will generally then be a solicitor for a little while. So a solicitor being the person that isn't standing up in court talking, representing, kind of the background person. Some people will just state that and they're happy to do that, and that's great. If you want to do a barrister, you generally are a solicitor for a while. I guess you could jump straight in. You sit the bar exam, and then you qualify as barrister. And that's basically how it works. So it's a little path. You still a law degree, legal training, generally solicitor, and then a little barrister link up there. There is no delineation between like the electives you pick. There may be certain electives that are more designed towards it, but that's a uni thing and that's a your choice thing. There's nothing that's going to stop you from doing that. Where can we find a guide to know which course we need to do at certain years? Excellent question. Every uni will be different. I'm so sorry, that's my answer. It's so annoying. Generally, your uni will have published some sort of progression. So if you Google like UNSW law progression, some things come up and, you know, insert your uni here. Alternatively, as you guys are first years, make sure you sign up to like your uni law society and whatever the kind of student mentoring programs are. So if you're at UNSW, Law Plus, yes, absolutely, sign up to it. Please do it. I'm not a mentor, I just think it's great. That you can then ask some older people. The other thing is if you get in contact with your law school student services, they'll be able to direct you. And as you get kind of further into your degree, you'll be able to do a progression check where you kind of email someone and say, hey, I just want to check I'm on track. And they'll send you back a list of the courses you've done and the courses you still need to do.